Okay, welcome back, my dear class. There were two things from the previous class that I wanted to explain. One was the reason for this, for reasonableness, why it's reasonable, why it's unreasonable for a company. We're thinking of the example when you could have a very cheap, you could buy some protection measure. The company knows if it puts in some kind of filter or some kind of protection measure, the accident will not happen. What the judge is thinking about, what's the incentive? The case that you compare it to is the case like strict liability, where the company always pays for the damage. The problem with this case is sometimes the damage is very rare to happen. It maybe only happens like once in 1,000 times or once in 10,000 times. So the company will want to gamble and think, I think this accident will never happen, so I will not build a protection measure because I feel it will not happen. The reason why the company thinks this is because if it's like strict liability, the company will pay every time. If the company thinks it will pay whether it does the protection measure or not, then the company will not do the protection measure because it feels like it has to pay no matter what. So what the judge that came up with this theory realized is if you say you are reasonable to put the protection measure and we will not make you pay for this very, very rare harm, then this is better in the end because now the company has an incentive. Now the company thinks it's much cheaper for me to just go ahead and build this protection measure, and then in the rare event something does happen, I've only paid for the protection measure, I do not have to pay for the entire damage. But what will happen is more companies will add the protection measure and there will be more protection in the future. Everybody's better off when these companies put the protection measure in. So do you understand the logic? There are the two examples, like strict liability and your no liability if you put the protection measure in, if it's reasonable. If it's like strict liability, but it's a company that we want to keep, then the company will not have an incentive to add the protection measure. If the company feels it has to pay every single time, then they will not do protection. They will gamble. But if you say, if you do the protection, you will not be liable, then the company will say, it's better for me to add the protection. This is why we have this rule. A company will not have to pay if it's reasonable. What reasonable means is, what should the defendant have done? What they should have done normally is add a protection measure. They should have added a protection measure. So what negligence is saying is, if you add the protection measure, you do not have to pay. If you add the protection measure, the defendant will not have to pay for the harm. So what happens is many defendants will add the protection measure and society will be better off. There will be more safety because they will want to protect themselves. Even if the risk is very rare, many of them will add the protection measure. That's the logic. Do you understand? Do you understand why the boss wants to add the protection measure? He has an incentive. So for many normal companies, we have this kind of rule. As long as they add the protection measure, they will not have to pay. They only have to pay if they do not add the protection measure. Because remember, companies, they don't care about people. If there's one lesson we have learned, companies do not really care much about people. Companies care about money. So if you tell a company, look, you can either buy this cheap protection measure or you can pay for this really high cost of harm, then the company will always prefer to buy the cheap protection measure. But that's good for us because if there's a lot of protection measures, then the harms will be prevented more often. So it's like a kind of language. This law is a kind of language to talk to the companies. It gives them incentives to want to add protection. It's a way that we can make companies want to add protection if we have this rule. And then later we talked about strict liability. For strict liability, we think the situation is so dangerous, they're making these dangerous things, that we don't even want to mess with this rule. We just say you are always liable. Even if you add protection measures, you're always liable because this is so dangerous. We don't even want to give you this incentive. Just this is so dangerous. So if you cannot pay for the harms, because the harms are so high, and if you cannot pay for them, we'd rather you just go bankrupt. So we only use this logic for negligence, normal kind of companies. All right, so that was one thing. That was explaining where this came from. I know I explained that a little fast, but just understand the basic lesson. Think about the boss and what he's feeling. What does he want to do? If the boss has a choice between a cheap protection measure and paying for the full harm, that's an incentive for him to buy the cheap measure to not have to pay for the harm. Think of incentives. So much of law, these environmental law, is thinking about what are the incentives? What is the boss thinking when he's creating a company that has chemicals going into the water or into the air? We want to change his thinking. And economics is one way to change his thinking. Sometimes they care more about the economics than they do the law. So we can use the law as a tool. So over the break, someone asked the question, we talked about with the strict liability, what happens when a company goes bankrupt? Can the victims ever see money when a company goes bankrupt? We said with strict liability, the market is telling us the costs are so higher than the profit that it's okay for you to go bankrupt. But they don't have enough money maybe to pay all the victims. What do we do about this problem? So I will tell you, normally when they have this kind of case, the company will know it will lose. What happens is the company will create a fund. And I think in fiduciary law you learned about funds. Did you learn about a fund? It's like a trust. And you learned about trusts?
Yeah.
It's a pool of money. It's a collection of money. They put it into a fund. There's a trustee who's in charge of the fund, and you learned about the duties of the trustee, right?
Yeah.
To protect the fund fiduciary duties. Anyway, what happens is the company knows it does not have enough money to pay all the victims. So what they do is they create a fund, and they put the money into the fund, and then they divide it. If there's, say, it's like asbestos, and there's 10,000 victims, they will divide the fund into 10,000 parts, and they say, we will give you this part. This part of the fund will be yours. But there's an agreement, it's a contract. And the victim signs and says, I agree, I will take this slice of the money. It's less than what I deserve. I can claim more, but I agree to take this 1% of the fund, and I agree not to sue you. So it's a fund. The victim does not have to take the money. They can refuse. But if they refuse and they sue the company, it's a gamble. They take a risk because maybe the company will go bankrupt soon. And if the company goes bankrupt, the victim can get no money. So that's why it's a risk. But this is a way with the fund, at least victims can get a little money. They do not get full compensation, but they do get a little money, which is better than if the company goes bankrupt. The issue about that is, of course, because the victim is entitled to the full compensation, you cannot force the victim to take it. I guess under contract law, maybe that might be unconscionable, but you cannot force them to take if they are entitled to more. So that's why it's a contract, an agreement. They may refuse, but if they refuse, it's a risk. So this is the typical situation when a company is going bankrupt, how victims can still get money, and how it's handled in law. Often in the bankruptcy proceeding itself, bankruptcy is a legal process itself. So often there will be a judge, and they will create a fund of all the assets when a company is going bankrupt to pay all the people the company owes. So that's part of the bankruptcy process too. So those were 2 points from the last class that I wanted to add. All right, let's go back to these poor animals in animal studies. So so when we're talking about health risks involved with certain chemicals, these are usually the two most typical types of evidence: epidemiological studies and animal studies. Which do you think is better evidence? If a judge is looking at it, which do you think is better evidence, the epidemiological study or the animal study?
Animal study.
Actually, the epidemiological study ends up usually being more persuasive because the epidemiological study is about humans. The issue with animal studies is, number one, they're animals. I mean, that's obvious, but we need a good argument. The scientists will have to tell us a good argument why the human body works like the animal body. So sometimes many animals may have different issues than the humans. So there's a little uncertainty. If an animal gets sick, does that mean the humans will get sick? And then the second issue is because of the time frame. Animal studies are usually very quick. They do not last 10 years. They will overdose. They'll give them 1,000 times the dose and see what happens in a few months. It's much faster. But the issue, some people will argue it's very difficult to connect 1,000 times the dose to the normal dose humans get. I mean, it seems logical that the sickness it'll be on a line. So if you have 1,000% the dose, you'll get 1,000 mice sick. You get 500 times the dose, 500 mice will get sick. And 1 times the dose, 1 mice will get sick. Sometimes it seems logical to draw that line, but sometimes we don't know what happens when the dose gets very low. The science isn't always that obvious. So maybe we can see what happens to mice at 1,000 times the dose, but that isn't obvious that that's what will happen to humans. So there's a little more uncertainty with animal studies. Epidemiological studies are usually more persuasive, but they're much more expensive and they're much harder to get because you need the huge sample size. You need a big population to do it, and you cannot control epidemiological studies. Sometimes you can't control how much water people drink, so that makes them harder.
Who prefer the epidemiological study?
Okay. Well, this is one of the movies I was talking about, maybe showing you. The issue in this movie was a very similar case. That was ground pollution. There was a company, and they're putting toxic waste burying it in the ground. And then it got into the water, and people were drinking the water. So it went from the ground into the water. And a mother's son died from this water. And so the mother sued the company. She had a very, very good case. But the problem was the lawyers had to pay for the animal studies and the epidemiological studies. The plaintiff has to pay. Sometimes you can get a research university that will do these studies, but in many of these kinds of cases, the plaintiff has to pay. And what they're doing is, it's a gamble. The plaintiff is saying, we will spend like $1 million for this, and we hope we get, $150 million settlement. They hope they'll get $150 million money from the company. But to do that, they have to risk like maybe $2 million for this study. Very expensive studies. And in this movie that I wanted to show you, in this case, a very similar case, they just ran out of money. The plaintiff wanted to spend so much money getting all this scientific evidence that they literally ran out of money. And he couldn't continue the case because he just ran out of money. And even there was one point in the movie, the company settled for like a lot of money, like $50 million, so much money, and he refused because he thought, under the law, I know I can get more. So he refused the money because he knew, he thought that the company was being overconfident. They're not giving us as much as we deserve, so he refused. But then, in the end, they ran out of money. Trials are very expensive. And if the plaintiff has to buy this science, it's a very difficult So of course, for a developing country, that makes it even harder. I mean, this is the problem with the common law. This is the problem with using common law to help environmental problems, because getting science to answer these questions like cause and harm can be very expensive. So sometimes the government does not have enough money to get this evidence, and sometimes plaintiffs do not have enough to get this money. It depends. Some are more expensive than others. But like I said, sometimes there'll be an NGO or a university, and they'll do the science for us. And if you have a university that will do the science for you, it's wonderful. Then the plaintiff doesn't have to pay for it. But it would be, you would hope the university would be independent. You would want someone independent giving you the science. Very often the company has science. The company has Fox, companies like Fox, they have their own scientists. And the scientists do these studies too. But do you think that's very good evidence to use in a trial?
No.
Yeah, maybe the scientists for the company, they have a strong self-interest to twist the science. So it may not be very good evidence for plaintiff. But sometimes even the plaintiff can use the defendant's own science to turn against them. It can happen. So, all right. So that's cause. All right. And then we talked a little yesterday about uncertainty in the science, especially with these health studies. Okay, well, let's look at the case we have right now. What claims are stronger than others? So we can say with the evidence, this is the evidence we would want to show the judge. So with this evidence, the color and smell claims are looking very strong. The cancer risk, we would have to spend a lot of money, and even when we get these studies, there's some uncertainty. There's a little uncertainty. And judges, remember, because judges are thinking about polluter pays. The judge wants the person that actually caused the harm to pay. So if there's uncertainty, we're not 100% sure who caused the harm. Maybe they got cancer from some other company. So then judges worry about uncertainty, about the risks, health risks. So that makes it an issue. So what about between nuisance and negligence? Which claim do you think evidence is stronger for? So you remember, yeah, nuisance. Why is it stronger for nuisance? That's a good answer.
It is interfere.
Yeah, looking at the evidence we have here, especially if we can show really strong evidence of the color and smell, it's very easy to have a claim for interference, the evidence falling for interference. And then caused by, remember on this element we're looking at cause, so where's the blue marker? Put it over here. So in this section we're looking at the caused by defendant element. Yeah, so defendant that causes. So caused by the defendant. This is the part that we're looking at. So interference caused by the defendant. On this evidence, it's very easy to show the color and smell are caused by the defendant, because color and smell is what's actually interfering. Now what's interesting about the cancer risk is you don't have to show cancer is for an interference. You do not have to show cancer as being caused by this chemical. What you have to show is fear. There are people around getting cancer, and the plaintiff is afraid, and that's interfering with his use of the land because he's afraid to use the water because of this cancer. So do you see how it's easier to prove the fear is causing his interference than it is to show that the defendant's chemicals is causing harm. So in negligence, we're talking about physical harm, like the plaintiff is actually getting sick. And you need to show that the defendant is causing the harm. So the defendant is causing James to get physically sick in some way, or a risk of getting sick. So under these facts, it's easier to show that the actions caused interference than it is to show that it caused actual harm. So that's why nuisance is an easier claim than negligence sometimes. For nuisance, with this evidence, we just need to show the color, the smell, and his fear about the cancer is interfering with his life on the farm. That's all we need to prove for the nuisance claim. For the negligence claim, we have to actually prove the harm is caused. And then that's uncertain. We have more uncertainty to prove that. So yeah, judges have a problem dealing with uncertainty. They want to create good incentives. So what judges will think about, if I make this company liable and they have to pay, what will the other paper mills do? Will the other paper mills change their behavior? Will this lead to less harm being caused in the future? So if these studies turn out that this chemical really is causing a lot of cancer, and then the judge makes them have to pay, other paper mills are not going to, if Fox has to be liable for negligence and pay a lot of money, all the other paper mills are going to change their behavior, because they will realize if Fox got sued, I can get sued too. So they will put protections to stop this chemical from going into the water. But there's some uncertainty, so the judge is thinking, are we really creating more health? If the judge is persuaded that this is good enough evidence to show some health, then it's really good. We really want to change behavior. So it's good to hold them liable because we want all these other paper mills to change their behavior. Judges are always thinking about incentives. That's why evidence is so strong for them. They're not just thinking about this one paper mill. They're thinking about all the other companies. How will they react? And they want them to be safer. So the risk of liability is an incentive for companies to try to be safer. All right, so this is evidence. The cause, let's look at the last term now. Harm or damage. So damages. What kind of damages can James actually get money for? What is the money actually for? What's the damages? And maybe they will be different between the nuisance and the negligence claim. So let's look at the nuisance claim. What's the actual damage he's claiming? Huh?
This farm.
Yeah, interference with the farm. But how does that translate into money? How do you translate that into money? What are you actually compensating?
Maybe he might have no work after water.
Okay, good. Economic damages. What? That's the risk. Judges are worried they cannot read his mind. So if he's maybe afraid to work, the judge wants to look at the actual economic harms, not what's going into his mind. So one thing you might look is something called, that we can talk about, stigma damage. So stigma damages just means people are afraid of the land. We're not certain whether there's actual risk there, but we're afraid of it. One way to put it into economic terms is the value of the farm. If he owns the farm and he wanted to sell it, the value of the farm, because of this fear, other people know about this water and they're afraid of it, so the land value goes down. Land value goes down. Land value drops. So his land, this is one very definite economic damage. His land is worth less now than it was before. It doesn't matter whether the cancer risk is real or not. People are afraid of it, and it creates... Has anyone ever heard this word stigma?
Stigma.
Do you know this term stigma? Maybe someone should... It's... So this is like a dislike from fear. A stigma is a dislike from fear. So that means, I don't know how well it translates, but it's some dislike from fear. So people are afraid of this water, and if he wanted to sell his farm, nobody wants to buy it. Even though the farmland may be perfectly good still, you can still grow crops and the animals will still be healthy. The people are afraid from the stigma. It's just a pure feeling of fear. The feeling of fear itself. But it's not imaginary because the land value is really going down. He's losing money on his farm. He's also people fear fear from his crops. People do not want to buy. Maybe he's growing corn. Also, the value of corn drops. Value of his corn drops. People do not want to buy his corn because they are afraid the water in it will be tainted and it will make them diseased. So these are actual losses. These are not Judges worry about imaginary losses, like a feeling. When someone goes to a court and says, the defendant did something and I feel terrible. I wanted to cry. I cried. And the judge will say, that's not a real harm. This is something in your... How do I know you're not just acting? Are you really sad or are you just acting? You want to show some actual evidence. So this is a way... One thing about stigma damages, it's coming from fear. Fear is a feeling people feel. You can't get evidence for feelings. Maybe they're acting. The one thing that is very true about it is the economic damages. Stigma drops the value. People do not want to buy the land, so the value of the land really drops. It's not an imaginary drop. The value is actually going down. The value of his corn, how much money he can make from his corn, that's really dropping. That's an economic loss. So it's very good when you have these kinds of... When you're looking at damages, they're very persuasive in common law cases if you can translate them into economic damages. Because Fox will argue fear is not a real damage. Fear is just something, maybe you're acting just to make money from us. Fear is not a real damage. But the stigma damages are a real damage because it's an economic damage. It's something you can translate into money. And it's very easy to show that the color and smell and these people getting cancer, it's very easy to show evidence that the reason why the price of his land and corn are dropping are because of these. These are going to be very easy to connect. But Fox maybe wants to argue, though, this isn't fair. Fox will try to argue they're not responsible for the land value dropping. Could you imagine Fox's argument, their argument, for something like the land value dropping or the corn value dropping? What will they say is causing that? They will probably say, we're not responsible for what other people feel. If we're creating fear, that's their fear out there. So Fox will probably try to argue this. So it will be for the judge to decide. But I think there's a very good argument that this value would not have happened he's losing money because of what Fox has done. I think it's a very good, especially for the color and smell. He's losing money because of this. So I think it's a very good argument. Even if Fox tries to argue, this is from other people's fears. We cannot be responsible for how other people feel. That's an argument they may try to use, but I think it's such a strong connection that the land is dropping, the value is dropping because people are afraid of the water. It's just, it's common sense. Sometimes many arguments just come down to common sense. Fox will say, we're not responsible for this, but the judge looks at it, and it's common sense. If people see brown, smelly water, they don't want to buy this land. They don't want to buy this corn that's watered by this. It's just common sense. So that's why it's very good evidence. But it's good to translate it into the economic damages.
Teacher,
Yes?
how many years after the falls become base and then the big the company?
How many years do what?
How many years after the people face this industry base, and then how long does it take to cause cancer, interfere genetically?
Well, the company has been there for many years. I think they said, since like the 1940s.
1940.
And then I think this case was like in the 80s. So it had been there like maybe 40 years, 30 or 40 years. And people were already getting cancer. Cancer, often is from like 15 years, 10 to 15 to 20 years from first exposure to getting cancer. Many, many years. Yeah, that's why it took, this was here for 40 years before they finally decided to sue. But I imagine it was getting worse. Maybe every year it gets worse and worse and worse. And then finally they just, they don't tolerate anymore. They must do something. So they finally sue. But yeah, it's going on now, still today. They're still talking about this case today. It's still not resolved.
Because was there, just to delay and just to deny. It took many years, and then we see after many years, and then the
Yeah. I think one reason is, I told you, the permit. Because they got a permit from the state. The permit was from the 1930s. Maybe we don't want to trust this permit anymore, but they got a permit from the state, so that stopped anyone stopping it for a long time. And the second reason is because they didn't know the cancer risk. Nobody understood, in 1950, nobody understood dioxin and cancer, the connection. But today, everybody knows this risk. So there's a lot more information about this risk now, so that's why they sued much later. But this is very common. It's very common that the lawsuits will come much later. And we can talk about environmental law distinguishes. Sometimes we want to distinguish a new company that wants to start building, and we want to give them a permit, a right to start developing, versus an old company that has been there for many, many years. Or like some of these mines, someone that has been developing for many years and causing maybe injuries for this whole time. We might have to treat those a little differently. We just have to look at the situation. And I told you from the beginning, so many harms in environmental law. They take so long before you start seeing the harms. So this isn't a rare case. This is very common, where it will be 20 years later before people see the harms, and now they want to sue. And now the company has been working there for 20 or 30 years, and they will feel very protected. They will want to know, why are you suing us now? Did you ever learn the statute of limitations? Statute of limitations is another principle in common law where if a plaintiff has a claim, he has so many years to go to a court. And if he does not go to a court within that statute of limitations period, then he will lose his claim. Sometimes it will be like 5 years, sometimes 12 years. So one thing about statute of limitations, it's from when the plaintiff knows that there's a harm. But for these uncertain cases, the plaintiff has more information over time. Sometimes it's hard to judge, when does the statute of limitations start? Because what the company will say is, you knew about this harm 20 years ago, you're too late to sue now because of the statute of limitations has run. This is another problem with common law that makes it hard to deal with sometimes if their statute of limitations clock runs out. All right. So this is probably the number one damage that he can claim for. The economic damages for the interference. And remember, this is a private nuisance claim, so this is just for James instead of public nuisance. Now the issue with negligence is the plaintiff usually has to be harmed in some way more than just interference. There needs to be some kind of actual harm to the plaintiff. So often negligence claims are harder for James to make for himself. Unless if someone from his family got sick, that's a very good claim for the damages, like the medical bills and damages from getting sick. But if he didn't get sick, we're only talking about these economic damages, the stigma damages. It's harder to have a negligence remedy. So very related to damages is remedies. So this is the number one kind of damage he can claim. Let's talk about remedies now. What are the remedies? How do we heal this situation? Let's assume that James has won either the nuisance claim or the negligence claim, and the judge wants to remedy this situation. What are the remedies the judge can do? How can we heal this situation? Or what are some things we can do to... What's that? Yeah, legal remedies. There are two major kinds of legal remedies.
Limit protection.
Limit the protection?
Protection.
Limit the production?
Yeah.
Okay, do you know the term? So you want the courts to order the company to change its behavior? Maybe to use less water or to use less chemicals? And do you know the name for this legal order? There's a name for this legal... When a court orders a company to do something, there's a name for this kind of order. Do you remember that?
Injunction.
That's right, injunction.
Declaration.
An injunction. The court can order an injunction against the company to change its behavior in some way. Now, one thing they could do is just order an injunction for the company to shut down and move. You have to move to another river or something like that. But do you think the judge would be likely to do something that drastic? Do you think they would order the company just to shut down, to stop production? Yeah, for a paper mill, they're probably not going to order an injunction to stop all production. They'll probably do what you just said, which is order an injunction to, change their procedure.
Policy.
Yeah, change their procedure or policy. So, use less chemicals.
Chlorine.
Yeah, use less chlorine. Or use a different kind of chlorine.
Chlorine.
Or less percent of the water. Or maybe some filter. Use a filter. Okay, so here's an issue with an injunction. It's a very similar issue that regulation also has, which is the government is essentially telling the company how to make paper. Not how to do every single thing, but they're saying for this one part, this is how you should make paper. Can anyone think of an issue? This is a judge that comes up with an injunction, and he's telling a paper mill how to make paper. Can anyone see an issue with that? Or what Fox's attitude may be to that? So I'm the boss of a paper mill. My grandfather made paper. I have been watching paper making since I was 2 years old. I've spent my entire life making paper. And now a judge has just told me, giving me instructions how to make paper. How will I feel?
Find new technology.
Yeah. The issue with an injunction is the judge is not an expert paper maker. And the paper makers may feel like, you know, I understand we need to clean up our business, but the advice you're giving us is not efficient. You're telling it, you know, maybe you're telling us to use a filter, but maybe filters are very stupid in the paper business. All the other paper companies are going to laugh at me because I'm making it in a very dumb way. So even if the paper company wants to clean up, they may worry about the specific instructions that the judge gives them because the judge is not an expert paper maker. So, but this is not the only option. Judges worry about this too. Judges can be very self-conscious. And the government, this is not just judges, also government agencies, they worry too that, you know, they're not expert paper makers either. So they worry too. Sometimes they don't want to give bad advice either. They don't want to punish people making paper if they do it safely. So another option, instead of giving them specific instructions, is an injunction like you must reduce the chlorine output. You must reduce chlorine output and the color and smell to, you know, X%. This is a different kind of instruction. You must reduce the chlorine output and color and smell to some low percent. That's reasonable. But you can do this anyway. Find any way you want to that will get this job done. This is maybe more efficient because the judge is not telling the fox how to make paper. They're saying you can use any method you want, but have this output. So there's a trend in environmental law today to move from specific instructions to open instructions, just giving them the goal, but the company can choose whatever method. The advantage of this is then the company can find the cheapest method. Like you said, new technology. The judge cannot predict what technology will come, but if the paper mill has an incentive, we know we have to drop before this, or we pay some fine, the company will look for the new technology because it will be much cheaper for them. They will find the cheapest way to meet the goal, to create safe paper. Sometimes this is more efficient so that we can still get safety, but the price of paper does not become very expensive. So this is one way. Governments worry about every time they add a restriction, you're making the product more expensive. And then all the consumers, all the people will have to pay for it. So sometimes they think about, you just give them a goal and let the company decide what's the cheapest way. You just want to, again, you always want to look at incentives. You don't want the company to cheat. So you want to have regular, to do this, the government needs to be able to check up. The problem with this is this may be expensive for the government. If the government just gives them a single order, I want you to do X, I want you to put on filters. And it's very easy for the government just to go and see the filters. But if the government just gives them this open-ended goal, reduce the chlorine to this percent, then the government has to send scientists with water bottles every year to check the chlorine level. And they have to keep coming back, to make sure it's still working. You have to follow up to make sure the remedy is being done. So there are issues with injunctions too. Injunctions can be very useful, but there are also issues. So an injunction is one legal remedy. What's another legal remedy? What's that?
Compensation.
Adequate compensation.
Adequate compensation, monetary compensation.
Monetary compensation.
So this is what we were talking about for just before over here. What kind of economic damage, what kind of damages he can get. So let's talk about generally. Injunctions are good to stop pollution from happening. Injunctions stop pollution from happening. Monetary compensation is good for things like past damage. You cannot have an injunction to help past damage because it's already happened in the past. So monetary compensation is good for past damage. And similarly, it's good for future damage. So an injunction, you know, maybe they put this filter on, but some chlorine will still get through. The Fox Paper Company will still continue to operate. So there will still be some future damages that can happen. If they do not shut down Fox Company, then they will still be putting the chemicals, even if they have to change less. So there will still be future damages that an injunction will not be perfect for. That's another case for monetary compensation, if the activity continues. And then we talked about, with the nuisance, the land value, you know, the crop value, things like that. These are economic damages. Direct economic damages. But maybe there may be some indirect economic damages. Indirect economic damages. So, for example, maybe you have a service where you take people on fishing rides, you rent out boats or fishing equipment. Say you're a little shop and you rent out, you sell equipment for fishermen, and now because the water is brown, all the fishermen have left. So you're not making as much money for your fishing business or your boat business. People do not want to be on the river. That's more indirect, and it might be harder to get that. You know, the James's economic damages were very direct because the water was on his land. But other people, like this fishing business, getting money from people that go fishing, that's more indirect. So there gets to a point of indirectness where it may be more difficult for them to claim compensation. What about the river itself? The environmental damages. The river itself. Can James get money for the damage to the river itself? The river itself has turned smelly and colored, not just for James, but all this, you know, this 30 miles of river is all brown and smelly. And that's a damage. Not just to the people, that's a damage to the river itself that we can all see. That has maybe costs. We can think about the costs different ways. Maybe one cost is how much would you have to pay to clean up the river? If you had some kind of service that could suck up the water and clean it out and put the water back in. Maybe that's very expensive, but that's a kind of cost. So this is in pure environmental damages. Damage to the river itself, not to any person, but to the river itself. Can James claim, do you think James can claim compensation for the damage to the river itself? Yeah, well, and then we can look at the different claims. I mean, under a nuisance claim, there's no claim to the river itself. The claim is for the interference with his land. There's nothing in here that says anything about the river itself. It's just talking about the interference. Yes?
What if this claim for the...
Oh, that's very good. Yeah. If it's a public nuisance, we can think about a public... Well, we look at negligence or nuisance. So for public nuisance, that's still talking about interference with the public's use. So that's still a little hard for the state to even claim under nuisance, because nuisance is still talking about interference with the public. Under negligence, you could say if it's state land, then that's a direct harm to state land. Maybe the state could get money under negligence for the direct harm to the land as state property. That's tricky because that's damage to their property. Under negligence law, it's thinking about it in terms of damage to its property, not environmental damage by itself. So the basic answer is judges worry about money for pure environmental damage. They want to see money, economic damages. Judges are very worried about compensating for environmental damage by itself, alone. So a very good example that I studied was the Exxon Valdez case again. Remember I was talking about the hoses? That was, they had these powerful hoses that was just killing everything, but it looked pretty. But they were paying, the compensation was not for this oil on the beach. There was a big oil spill and it went all in this beach. The compensation was not for the oil itself. The compensation was for cleaning, the costs of cleaning. That's what they were paying for. Because the judge did not know how to, the problem with, so the state did claim the money and they got compensated. But the judge wants to know, how do I value? How do I value? This is what the judge will ask. How do I value the environmental damages? Even if the judge wants to give the state compensation for the environmental damages, they'll want to know, how do I value it? Because there's not a price tag on the beauty of a river. He doesn't know even how to think about it. Or government agencies don't. But what they can do is they can put money on actions. So like the cleanup costs. The cleanup costs have a definite cost we can all see and agree on. So that's much easier to get compensation for cleanup costs for the state. It's much harder to get compensation for just pure environmental damage. But that's true. The state may be able to get money for the river to clean it up. Not James. James would not be able to get money for the river itself. James could probably get money under nuisance for the interference. James may not be able to get any damages under negligence because they wouldn't recognize a harm. It would be harder to say the harm because the interference is much easier for the evidence. All right, this is everything I wanted to say about James versus Fox.
We're talking for 2 days,
Huh? A day, well, one day if you count, it was half of one day and half of the next.
Okay.
Does that count like for one day? All right. So now we're going to move on. I wanted to teach you just some general tort principles. Since you have not taken tort law, I wanted to teach you a few other general principles that didn't come up into this case, but are good to know for environmental law. So, see, I'm doing cost-benefit analysis. If I want to spend all the cost to erase all this, it'll be such a huge cost, but will it be worth the benefit? But there's an administrative cost. I'm wasting time thinking about it. But now we have a side payment that reduces the administrative cost.
Can we say like this case is human rights violation?
We will turn to human rights and environment. The common law has problems with that because we were looking at it before, duty, breach, cause, and harm. These are the things you have to prove under the common law claims. And human rights do not fit very well into this always. Especially, human rights does not fit very well into the economic thinking. Because, I was talking about how judges and the government so often want to translate in economic terms. So they're thinking about human rights violations. They're thinking about in terms, can we give them enough money? You know, if you're building a dam, they're only thinking how much money the dam is generating versus the cost of giving the villagers new money to move to a new house. You see what I mean? This is how government agencies think. They have these, you know, have you seen the computer program Excel? It's like a computer program where you have these you know, these lines and charts and thousands and numbers, all these numbers everywhere. And so the government agency is they're looking at the benefits, economic benefits of a dam. They create this much electricity and we can have this much new business creating this much new economic money for all these people. And they look at the cost of moving the village. You know, we have to pay for them to get some new house and, you know, and moving costs and things like that. So they look at that and they say, look, the benefits, the economic benefits are so high and these costs for dealing with these villages are so low. So this is a great, you know, this is, overall society is winning. But, you know, again, it's the fairness issue. That it's good economic thinking, but it avoids the fairness issue because all the benefits are going to one group, but all the costs are being borne, and that's unfair. It's worth, you know, they're thinking about economic terms of cost and benefit, but they're not thinking, you know, some of these costs to have, like, for example, FPIC, free prior informed consent, and to consult with the village, and to give them adequate, more compensation, and to follow up to make sure the villagers are really, you know, rehabilitated and able to move, and socially that they'll be able to survive in the new location. You know, those have extra costs, and in economic terms they just see they're spending money, but what they don't see is that it's rebalancing the fairness issue. And fairness is not something you can put into economic terms. Who's bearing more of the cost and who's getting more of the benefit? You can't always see that in terms of money. We have to look at the situation and what's going on the ground. So that's how human rights gets into environmental law. So the issue is that environmental law is built on this economic thinking in the past. So we need to think about how environmental law can change its thinking so that more human rights notions can get inside of it. And that's like adding provisions for fairness. You know, not only is it when you pass a regulation, you know, government agencies are supposed to look at cost of benefit analysis. Is this economically efficient? Maybe we should have another requirement. Is it fair? Is there a balance of equity in this issue? That was the last topic I was on was remedies. That's actually something I was going to mention. Courts today, when they're thinking about what to compensate for, very often they use common sense and they do balance of equities. So okay, so I guess I wasn't done with the case exactly yet. So with the river damage, if they're balancing equities for James's case, what that means they're doing is they're balancing James' need to work on his farm versus what the paper needs to make paper. And they're balancing the fairness issues between those two things. So, but this is different in a public nuisance case. They would be balancing the paper mill's ability to make paper versus the public's need to use all of the river. So, you know, of course the judge would want to give a public nuisance a lot more money, a lot more compensation, because they're trying to balance what's fair to give different groups and what's fair to burden on the paper mill. It's more fair to make Fox pay more money for a public nuisance to the whole community. It's more fair to make them pay money for that than it is to pay money only for James. If they only have to pay for James, you know, the judge will think it's not as fair to make them pay so much money just for James. But if it's a public nuisance, the judge will think it's more fair to put a bigger burden, to make Fox pay more for the whole community. So, but the lesson there is judges balance equities. When they're thinking about the proper remedies, judges often use. Do you understand the term equity? Equity is another word for justice, but what's fair? Yeah, it's the way that law deals with fairness. But again, even then, they're thinking about in terms of economic terms. So even with the public nuisance and equity, they're thinking about the economic damages of the public. So one thing we might to think about how to get human rights into environmental law is to expand our thinking of equity to also include human rights, fairness for human rights. When you're thinking about damages and remedies, what are fair remedies? All right. So I wanted to teach just a few, few tort general principles. One is under cause. One of the standards for cause, I told you the but-for test before, right? Do you remember the but-for test? This is one common, there's, in common law, tort law, there are two kinds of cause often, which is actual cause and legal cause, which is also called proximate cause. Proximate cause in the US, and then remote cause in the UK. So US likes to use the term proximate cause, the UK likes to use the term remote cause, or not remote cause. So actual cause usually uses the but-for test, which means, you have A and he causes this damage in B. The but-for test means if you take away A, does the damage still happen? Still damage. Take away A, is there still damage? If yes, then not cause. If no, actual cause. So if we took away A, is there still damage? If yes, if there's still damage, even if you took away A, then A cannot be the cause of the damage. If you took away A and there's no damage, but you bring back A and the damage happens again, then A is the actual cause. So this is actual cause. This is actual cause, uses the but-for test. Legal cause, the reason why they often talk about legal cause is when they're talking about what's reasonable for a defendant to do, the effect should be foreseeable. The effect should be foreseeable. So very often in common law, tort law, the judge will not hold the defendant liable for an effect that's not foreseeable. So I will give you an example. This is called the Pilgraph case. In the Pilgraph case, there was a train. It was a train platform, and then there was a passenger, and he was holding a box of fireworks. And then there was an employee of the train. He didn't have a ticket or something. An employee ran and said, hey, you got to pay for your ticket. And then the passenger got scared, and he dropped his box of fireworks. Okay, now this is what happened. The box of fireworks fell under the train. The train ran over it, and the fireworks started going off. Okay, so the firework hits the platform, and then the platform shook. Okay, so now there was a stand, and on top of the stand was a scale. this thing. Yeah, there was a scale up on this roof. Okay, so there was a guy, he was standing here, and the scale fell on his head. So do you see what happened? That goes, hey, stop. Box, fall, fireworks, shot, hits table, scales fall on his head. Okay, and he wanted to sue he saw this, he wanted to sue the train company, because he said, but-for, look at the but-for test. The claim was the employee, his running. The employee surprised the guy. So this is the claim. This is why he said it was unreasonable. He unreasonably surprised the guy. So under the but-for test, if you took away the employee surprising the guy, does the damage happen? He does not get hurt. If the employee was not running and scared the guy, then he would not drop the box, the fireworks would not go off, the scale would not fall, so there's no actual, so it would not happen. So under the but-for test, he actually caused, the employee actually caused the damage. But the judge said, this is stupid, to hold him responsible for this maze of causes. There comes a point where if one cause causes another thing, causes another thing, causes another thing, A causes B, causes C, causes D. There comes to a point where we can draw a line and say you should not be responsible for these things that come afterwards. And the test they use for that is foreseeable. Yeah, the defendant should only be responsible for what's foreseeable. Yeah. So this is different. So but-for test is not enough. We should also look at legal cause. Do you know the term proximate means nearby?
Nearby.
And then the UK uses remote. So not remote. It's the same idea. Foreseeable. What can we expect the defendant should know? So in this case, if the guy was running afterwards and he dropped the box, and the guy wanted to sue for his losing the box, he lost all his fireworks. So maybe this guy has a good claim. It was foreseeable. If the guy's holding a box and you yell at him, he'll drop it, and he loses his fireworks. That's foreseeable. So maybe the first leak is foreseeable. But the fireworks going off, hitting the platform, and the scales falling, that's not foreseeable. No one can expect this to happen. So this is a very important test in cause. So one thing I studied was what's foreseeable may change over time. So I looked at a famous human rights case about mudslides. There was mudslides, and then there was a case, is the government responsible for building a wall to stop this mudslide? There was a mudslide and there were some villagers that were hurt by this mudslide. And the question was, is the government responsible for putting up a fence to stop this mudslide from happening? And the government argued, this storm that came was so big, we did not expect it. It was not foreseeable. This is an unforeseeable big storm. And the government and the judge was very sympathetic that this was such a huge storm. This is like a once in 100-year storm, so big that it was not foreseeable. Now the issue with this is this can change over time, because with climate change, something like big storms are no longer unforeseeable. Big storms are now foreseeable. So there used to be an argument, like, the 1 in 100-year storm is unforeseeable. This kind of argument, that's a 1 in 100 years. This storm only happens once in 100 years, so it's unforeseeable. There are many cases that have this kind of form, but now we can say, actually, today and maybe in the future, we can see these kind of storms every year. Maybe every year, or every 2 years, we're going to start seeing storms like this. So you can no longer argue that it's not foreseeable. So this is an important thing. So history, the lesson here is history is not always a lesson in what is foreseeable.
History is not always a lesson.
So, we may have this storm that's never occurred in the past, but with climate change, we may expect, these storms are now foreseeable. They have not occurred in history, but they are now foreseeable. Do you see the difference? Because the climate has changed. So history will not tell us. History says these storms do not happen, but they are still foreseeable because of the climate change. So sometimes, because the defendant will always say these storms did not happen in history, so that's what we can foresee. But sometimes, some scientific knowledge will tell us this should be foreseeable. All right, and then one other really quick thing I wanted to teach about is allocating responsibility. Sometimes you have cases with mixed causes. So let's give you a case like, here's a forest. Then you have A here and then B here. A and B cause a fire. A starts a fire and then B starts a fire. And then A will say, A will use the but-for test. If I didn't start the fire, B would have still started the fire and it burns down. And then B says the same thing. If I didn't start the fire, A would have started it and it all burns down. So they both use the same argument and then both want to say we're not responsible. But what do you think should happen? Yeah, in this case, both should be responsible. So in a kind of case where any one person is responsible for the entire event, then you can hold them. You can hold one or the other or both. This is called joint and several liability. Joint and several liability. Joint means you can sue both of them together, like they're cooperating. And then several means you can even sue one individually for the whole thing. Maybe A is a very rich company and B is a poor peasant, poor villager. If you sue B, you're not going to get any money, but if you sue A, you'll get a lot of money. So you can sue A for the entire thing. Because they're also several liability. They're joint, you can sue both, or several. You can sue any individual for the whole thing. So we need this argument to prevent them both arguing the other one caused it, and that would be unfair. So that's one example. And the last example I wanted to talk about was when you had many companies putting in a lot of chemicals. Like say this is like a river, and then you have all these companies and they're all putting some chemical in that all combine to a sickness, and then sickness comes out. And then maybe this is like 10%, 20%, 30%, 20%, 20%. All right. So one thing that judges have started to do in this kind of case is they will apportion responsibility. So A will have to pay 10% of the compensation. B will have to pay 20% of the compensation. Some judges will think about this, allocating responsibility by allocating responsibility by the contribution. That's one thing that judges will look at. So those are the extra things I wanted to teach about tort law. Okay, that's all for today. Thank you, my dear class.